Please open court.
Hear ye, hear ye. So on Part 3, the Chancery Court of Shelby County, Tennessee is now open for the transaction of business suit to adjournment. All persons in business with this court, draw near, give attention, shall be heard. Honorable Chancellor Jode Jenkins, Judge Deborah Stevens, and Judge Gary McKenzie presiding. God preserves these United States of America. Honorable Court, please be seated.
All right, good morning, everyone. Mr. Rudolph? Are we ready to proceed?
You're ready to proceed, Your Honor.
Call your witness.
Defendant calls defendant Stephen J. Mulroy.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I did.
You may proceed.
State your name for the record.
Steve Mulroy.
You are the Shelby County District Attorney,
That is correct.
and that's for the 30th Judicial District.
Yes.
When did you become Shelby County District Attorney?
I was elected in August of 2022 and sworn in and took office September 1st, 2022.
Can you briefly describe for the court your educational and legal background?
Sure. Cornell University undergraduate, William & Mary Law School, Federal District Court clerk for a couple of years, then a Department of Justice attorney for about 9 or 10 years. Then I became a law professor at the University of Memphis in 2000.
When you were at the University of Memphis Law School, what kind of courses did you teach?
At the U of M Law School, I taught criminal law, criminal procedure, constitutional law. I also taught throughout the entire time civil rights, and for part of that time, voting rights and election law.
Now, you've been sued in this litigation in your official capacity as the Shelby County District Attorney. Is that
Yes.
correct?
Yes.
Are you familiar with the Torch Electronics gaming devices?
Yes.
Once you got into office on September 1st, 2022, when did you first start having any official discussions about the Torch devices?
That would have been in November of 2022 when I got a memo from the Torches Council.
That's not too long after you got in office.
I was only in office for a couple of months. I was still trying to find where the bathroom was.
Okay. I'm going to ask you, we've got documents that have already been marked as trial exhibits. I'm going to try to call them out, so the ones on top. I have you look at trial exhibit 8.
I see it.
What is this document?
That is the memo that our office received from the counsel for the Torch Company. It's November 2nd, 2022.
Did you review this memo?
I did.
Did you meet with Bruce McMullen of Baker Donaldson about the Torch gaming devices?
I did.
Is it normal for you to meet with individuals or entities preemptively to determine whether their conduct is violating Tennessee criminal statutes?
No, that is not the norm.
Why did you do it in this instance?
Well, I mean, just as a gesture of good faith, I wanted to give them every opportunity to make their case and hear them out with an open mind.
After receiving the legal memorandum that's trial exhibit 8 and meeting with Baker Donaldson attorneys, did you also meet with Torch officials?
Yes.
Which Torch official did you meet with?
Mr. Stephen Miltonberger.
And he's the owner of the company?
Yes, that's my understanding.
After meeting with those persons, did you make an initial termination as to whether these Torch devices were gambling devices?
Yes, based on the representations that had been made both in the memo and in our first meeting with the Torch folks and their counsel, I did make such a determination and communicated that to them, or had my prosecutor, Dennis Johnson, communicate that to them in November of 2022.
I feel look at trial exhibit 1, is that the email from Dennis Johnson that communicated your position on the torch devices at that time?
Yes, it is.
And that, the date of that email is November 9th, 2022?
Yes.
Did your district attorney office policy change on the torch gaming devices at some point after November 9, 2022?
Yes, it did. Our position did change.
Can you describe the reasons why you changed your district attorney office policy on the torch gaming devices?
Yeah, there were two main reasons. The first one was our initial position, which was a preliminary position, was in reliance on representations that was made by the torch company about how the machines functioned. And in 3 different respects, we later found out that in the field, on the ground, the way the machines actually were operating, they were not in accord with those representations.
Did you order an investigation of the torch gaming devices by the Shelby County District Attorney Criminal Investigation Division?
I did. In early 2023, we began to hear reports about the fact that it wasn't in fact the case that you could get a preview without first putting money in. And it wasn't in fact the case that, in the language of the November 2nd memo, the entire balance of previews could be seen. And we also began hearing reports about a timer that created a great delay in being able to see the next preview. This was not in accord with the initial representations in the November 2nd memo and then the first meeting. And so that was why I decided to ask our investigative division to go out into the field and actually see what was going on with these machines.
And did they in fact do that investigation for you?
Yeah, in June of 2023, they did that investigation and then reported back to me.
Okay, if you'll look at the trial exhibit, I believe it's 17.
I see it.
Is that the investigative report that you ordered?
Yes.
Did you rely on the investigative report in determining whether you needed to change your district attorney office policy on whether torch devices are gambling devices?
I did.
All right, let's look at trial exhibit 2.
I see it.
Can you identify this letter?
Yes, this is the July 2023 letter, the letter where we put Torch on notice that we had changed our position in light of what we had found out and that we had considered the Torch machines to be illegal gambling machines in violation of Tennessee law, and asked them to cease and desist their operation and gave them until August 10th of 2023 to remove the violative gaming machines from Shelby County.
And the date of that letter was July 25th, 2023?
That's correct.
Did you reference the investigation that your office did in your letter?
Yes.
How did the investigative findings square with what was in the memo that Baker Donaldson sent you?
There were a number of differences between what had been represented in the initial memo and the initial meeting and what the investigation found on the ground. First, you were not able to see a preview without first putting money in. Second, you couldn't see the entire balance of preview outcomes as had been initially represented. I believe Dennis Johnson in his email talked about a full script. And then third, we found that all of the machines that the investigators found had a 50-minute timer, which in my view meant you really couldn't, as a practical matter, see any of those preview features.
Now, you mentioned about issuing a cease and desist directive in this July 25th, 2023 letter. Is that correct?
Yes.
All right. In Exhibit 2, where is the language on cease and desist?
Would you please give me a moment? Okay, the final paragraph of the letter on page 3 of the exhibit, I guess it would be the second sentence, where it says, "Your client and the businesses where these machines are in use are directed to cease and desist the operation of these machines upon receipt of this letter, but by no means shall these machines be found in operation in Shelby County on or after August 10th, 2023.
And did you mean that? What did you expect Torch to do?
I expected Torch to remove the violative machines from Shelby County, and I expected to not hear further reports of the machines being operated in Shelby County.
All right, and that cease and desist directive was to be effective August 10th, 2023?
That's correct.
So the date of your letter was July 25th, 2023.
Yes,
So you gave them some time to get the machines out of Shelby County, did you not?
I did.
All right, did Torch Electronics respond to your July 25th, 2023 cease and desist letter?
Yes, I believe sometime in August of 2023, a counsel for Torch responded back and basically asked us to reconsider, and if there were changes to the configuration of the machines that might make them legal.
All right, let's look at Trial Exhibit 3.
I have it?
All right, is Trial Exhibit 3, is that the response to your cease and desist letter of July 25th, 2023?
Yes.
All right, was there anything in, and this letter was from Bruce McMullen, right?
That is correct.
Baker Donaldson,
Yes,
the attorney for Torch.
that is correct.
Was there anything in Mr. McMullen's letter, Trial Exhibit 3, that changed your mind about the legality of the Torch devices?
No?
Did Mr. McMullen admit in his letter that Torch had not informed you that Torch had added a 50-minute timer to the devices?
Yes.
Did that concern you?
Yes.
Why?
It seemed to be a material omission, especially since in our first meeting in November of 2022, we did go over how conveniently it would be to be able to look at all of the preview features. And we got the definite impression that one could look at the full balance of the preview features relatively conveniently. The fact that there was a 50-minute delay, that one basically had to wait an hour for the next preview, in my view, was a material departure from what originally had been represented. And the fact that it had been operating that way for months without Torch notifying us did cause me some concern.
Right, did you subsequently respond to Bruce McMullen's letter to you of August 10, 2023?
Yes.
All right, let's look at Trial Exhibit 4.
I see it.
All right. Was this letter, Trial Exhibit 4, your response to Bruce McMullen's letter?
Yes, it was.
What's the date of this letter?
October 23rd, 2023.
What was your response?
Well, we had done further consideration and further legal research and further consultation, in addition to the consultation we had already done previously with the Attorney General's office, and had come to the conclusion that these machines were, in fact, illegal. And two things. One, we did not want to have to be in the position of constantly using our CID agents to go around and check to see whether the Torch machines were actually as represented. And so therefore, continuing to haggle over what adjustments to the configurations Torch would make was not something I was interested in. But also, second, regardless of the configurations, they still, in my view, were violative of the anti-gambling statute. So this letter in October of 23 was my final word on the subject. I mean, I actually used the word final in the letter itself, and it basically said, we've gone out of our way to reconsider. We have not changed our position. It's still our position that these machines are in fact illegal and they should not be operated in Shelby County.
Did you reaffirm to Torch Electronics the position of the Shelby County District Attorney's Office as to the cease and desist directive?
Yes,
Was that cease and desist directive, it still was in effect August 10th, 2023?
that's correct. It had been in effect the entire time between August 10th, 2023 and this October 23 letter, and continued to be in effect afterwards, in fact, until the present day.
In this letter, did you answer the questions that Torch Electronics had about your interpretation?
Yes,
And you testified, you indicated in this letter that this was your final determination?
yes,
You used those words.
yes, final decision on the legality of these machines under Tennessee law.
Now, there's been some testimony from Stephen Miltenberger at this trial. You've been here at this trial.
I have.
And the testimony is that Torch is still waiting for a response from you.
Yeah, I heard that.
Is that accurate?
I can't see how it could be accurate. I was pretty definitive in my October 2023 letter. I specifically referenced the fact, I understand that they were offering to take the timer down, to change the feature about, being able to look at the preview before first inserting money. I said explicitly, I considered that, and nonetheless, I was sticking by my original decision of July 2023, and I characterized it as my final decision. I don't see how I could have been any clearer.
The effective date of the cease and desist directive was August 10th, 2023. Is that correct?
Yes,
All right, since August 10th, 2023, has Torch Electronics complied with your directive?
no,
Has Torch Electronics removed its gaming devices from Shelby County?
no,
All right, you sat through this trial. Has there been any evidence offered by Torch that changes your interpretation that the Torch devices are gambling devices?
I've sat through the trial and I've listened very carefully. The answer is no.
We pass the witness, Your Honor.
Mr. McMillan?
Mr. Mulroy, you and I met several times in this matter, is that correct?
That's right.
And we've known each other even longer in this matter, is that correct?
That's also correct.
Let me ask you something. You just said something that I heard for the first time. You said, irrespective of how the machine operates, you felt like they were gaming devices, and you said, and besides, we didn't want to have to monitor the time on it to see if it was configured right. This is the first time I've heard you say that that was one of your considerations for asking Mr. Miltenberg to cease and desist.
Well, I'm sorry, what's the question?
This is the first time I've heard you say monitoring had an impact on your consideration whether to cease and desist. Is that correct?
I don't know if it's the first time you've heard that, but
But that is true, right?
yes, yes.
And monitoring, you're the DA's office, y'all monitor a lot of things to see if they're in violation. Is that correct?
Well, usually that's law enforcement's responsibility, but there have been times in which CID has gone to monitor things.
Right. So that's a part of your job. And let me ask you something. Did you see the game operate yesterday?
Yes,
And you saw that it seems like the biggest issue we have here is the time. The 3,000 seconds seem to be the issue that you have a problem with. Is that fair to say?
within the category of deviations between how it was initially represented and how I found it, that is the most concerning of the three. That is true. I have other concerns about the legality of it, but yes, I think of the three deviations between how it was represented and how it actually operates, the timer is probably the most concerning of the three.
And I'll get into how it was represented later, but the timer, is that a part of your consideration as to whether it's legal or not, or it's just something that irritates you?
I don't think it's fair to characterize it as something that irritates me. I do think it is a concern because it makes it even worse. Because, you know, the argument is that somehow the preview feature makes it not a gaming device. And I think that's contestable. But to the extent that that is part of the argument, the fact that as a practical matter, you can't really use the preview feature does seem to be of concern to me.
And you know that that preview feature is configurable, is that correct?
That is correct.
Okay, let's go back and talk about when Mr. Miltenberg and/or me came into your office and discussed this matter. Initially, would you agree the initial version of the game had just a prize viewer where you just saw, you put no money in and you pressed it and you could see whether you would win on that road?
That's my recollection.
And you had some concerns about that with respect to a player would be playing for the second row. That's the chance that he would be betting on. Was that your concern about that?
I honestly don't remember if I said that at that first meeting in November of 2022.
But you do remember that you were concerned that it only showed the first row and nothing else.
I honestly don't remember that.
Do you remember in the meeting, Ms. Miltenberger offering to make certain changes that made you comfortable with how the games operate?
I don't specifically remember that, but I know that at several times throughout the process, you made those kinds of offers.
Okay, and the games were changed to a balance viewer at some point, is that correct?
That's my understanding.
And the balance viewer would show all the outcomes throughout the balance of money that was placed in it, is that correct?
Right, not the entire balance as I initially understood it from the initial November memo, but as many rounds as you paid for, as was demonstrated to me in our second meeting.
Okay, and so that was the balance viewer. Now, I understand the timer wasn't discussed at that time, but did you receive information on why the timer was necessary or was used?
I believe in your August of 2023 letter, when you responded to our July letter saying, hey, cease and desist, you provided some explanation for that.
Some context. And is it fair to say that Mr. Miltenberger's representatives were in constant contact with you? Is that fair to say?
There were a number of contacts. I don't know if I would characterize it really as constant, because there were long periods in which we weren't in contact.
Right, but there were meetings set up, that you had a very busy schedule, you must admit, is that correct?
That is correct, yes.
And Ms. Miltenberg's team reached out to you several times, and you accommodated the team, but with setting up meetings, but you could not be available immediately every time you asked. Is that fair?
Yeah, I mean, I think it's the case that Torch or its representatives reached out a number of times, and that I accommodated them with multiple meetings, and those meetings didn't take place immediately, but they took place fairly soon after the request.
You do agree that there are, for lack of a better term, copycat games, or other games that look similar to Torch that operate in the same venues that Torch operates?
That's my understanding.
And did any of those owners reach out to you early on to get clarification on the legality of it?
So it depends on what you mean by early on, but in the period of time in which Torch reached out, in late 2022 to early to mid 2023, there were no other machine companies that reached out to our office. Torch was the only one. Now, somewhat later, I can't recall whether it was late 23 or in 2024, we got an email from another company, but that was it.
Yeah, just an email, but in all fairness, Mr. Miltenberger wanted to explain the game, wanted no misunderstanding, and he reached out, and he made modifications to the game pursuant to conversations with you, is that fair?
I'm not sure that I would concede that he didn't want any misunderstanding because of the, aforementioned misrepresentations that I noted, but it is the fact, in fact, the case that Torch did proactively reach out to the DA's office. That is certainly the case.
And Dennis Johnson, part of your team, did he advise you that Torch had reached out to the previous administration?
I believe so.
And that would have been your predecessor.
That's right.
So, Mr. Miltenberger, even before you came, was reaching out to the DA's office to explain his game and get input on what would be acceptable for him.
So I think that's right. I don't have a firm memory of that, but I have no reason to dispute that. And I do recall that our office was conferring with the Attorney General's office about the legality of these machines even before I took office.
Okay. And you talked about clarification, but do you remember on Exhibit 8, if you look at Exhibit 8?
Please give me a moment.
I'm sorry, it's not Exhibit 8. Do you remember the email received on November 30th, 2022, from, I think that was from me, offering a clarification of how the game operated?
Yes, there was such an email. I think it was from you to Dennis Johnson.
Right, and it was addressed in a previous email when Dennis Johnson explained what was acceptable to you all and what your understanding of how the game worked, right?
Yes.
And so Torch reached back out to you through their attorneys and said, wait, hold on, let us get a clarification. Let us clarify to you that it doesn't work the way you described it in the email. This is how it works.
So my memory was that the only clarification was about what it meant to look at the entire balance of views and to clarify that it was only as many views as you paid for. But there was no clarification about having to put money in to see the preview to begin with, and there was no clarification about the timer. That's my memory of that email.
That's close, but let's be fair. You didn't pay, the game didn't pay for a view, did you? You could get the money back out of the game if you were dissatisfied with potential outcomes.
I guess it's a matter of semantics, but are you asking, if you're asking me, can you cash out? Yes, my understanding is you can cash out.
Okay, and you just had a misunderstanding at that time. You thought without putting any money in, you could pick out a number and go through and see the views, and that was your understanding. Is that correct?
It was my understanding, based on the November 2nd, 2022 memo and our first meeting, yes.
Okay, and we clarified that by saying you had to put money in because it was a balanced viewer. It had to have a balance to know when to stop.
My memory is that you clarified that in that November 30th email back to Dennis Johnson. I don't know whether I was aware of that or not, but certainly by the time of our second meeting in, I believe it was May of 2023, that became clear.
Okay, and putting the money in and being able to see the outcomes to the balance, and you were aware then if the player was not happy with the outcomes, the player could press a button, cash out, and get the totality of their money back. You were aware of that?
I was aware of the cash out feature, yes.
Okay. Now, in the August 10th letter to you, they were outlined the two real concerns that response. It was response to your letter that was sent previously in July. And in this is Exhibit 3, it says you appear to have two areas of concern: the activation
I see that language in the letter, yes.
Do you not agree those were your two major concerns?
Well, as I mentioned earlier, I think I was concerned about three different departures from the way it was originally represented and the way that our CID team found it in the field. Those two, plus the whole issue about being able to see the entire balance of outcomes, which we just finished talking about.
Right, okay. And so, in the letter, Ms. Miltenberg offered to alter any of those two things in order to accommodate your concerns, is that correct?
That is correct. Well, you did, I'm sure, on behalf of Mr. Miltenberger, yes.
Okay, and then you took the position in your response letter, and this letter was sent to you on August 10th, 2023, that's Exhibit 3, is that correct?
That's correct.
And then in October, you didn't respond to that until October 23rd, 2023, is that correct?
Well, that's correct, and that's because we took a fair amount of time to do further legal research and to consider it and come to a final conclusion that even if you had made those two configuration changes, it would still, in our view, be in violation of the anti-gambling statute.
Okay, and let's look at your Exhibit 4. Even in this exhibit, because in all fairness, Mr. Mulroy, Mr. Miltenberger's team communicated with you not only by letters, but also verbally, is that correct?
Well, I know that the team communicated with me in 3 different in-person meetings. I know there were several emails. It may very well be the case that there were people on the team who communicated telephonically with Mr. Johnson. I don't know, possibly.
But let's look at your letter, which is Exhibit 4, the second paragraph. You said, and this letter is dated October 23rd, 2023.
Mhm.
And then earlier this week, you state, earlier this week, you informed me that your client is willing to take the timer down altogether with a single price reassuring without any money being put in.
I see what you're saying. I guess it must have been a phone call that we had that I don't remember.
Right. And the point I'm trying to make, Ms. Milberger's team was in constant contact with you. And I understand you were very busy and you couldn't respond immediately because you have other constituents you got to deal with.
Right.
But Mr. Miltenberger is the only game maker who came to the administration even prior to you and was in constant contact, analyzing what he could do to make you comfortable with the legalities of the game.
I don't want to sound like I'm quibbling. I don't know whether I would agree about constant contact, because I believe in the chronology that there were significant gaps in which we weren't in communication. But I'm not trying to quibble with you. Torch was alone among those gaming machine companies that made repeated overtures to the DA's office.
Okay. And initially, you had approved it and you felt like it did not violate the gaming statute.
That is true.
Okay. And it seems to me you got a little frustrated because of things Mr. Miltenberger did when he tested the configuration that you approved, and you just said, I don't want a game, period, regardless of what you do. Is that a fair characterization?
I don't think that would be a fair characterization, because I think it suggests that I somehow got emotionally mad or something because I saw a disparity between what was observed in the field and what was represented, then I sort of lashed out. And that wasn't at all the case. I was concerned about the differences between the way it was originally represented and the way my CID team found it. But then when you, Mr. McMullen, said, well, we offered to make those changes, then I had to do sort of some sober, careful legal research. And I did more legal research, and I came to the conclusion that even if those changes had been made, it would still be in violation of the anti-gambling statute, because I had taken a look at the case law that suggested that it was. And so at that point, not because I was lashing out because I had been lied to, but because I took my time and consulted with the AG's office and people in my office, and I came to the legal conclusion that no matter how you slice it, they were gambling machines and they should be taken out of Shelby County.
And that wasn't your opinion early on, no matter how you sliced it, they're gaming machines. Early on, you met with us, you looked at it, and you said, if these things are done, I will approve it. Is that correct?
I think that's true because at the time I hadn't seen all of the case law that brought me to the conclusion that no matter how you slice it, these are gaming machines and they're in violation of a very broadly worded anti-gambling statute.
And well, let's talk about it. But in all fairness, early on, with the modifications you asked for, you were okay with approving it. And you yourself, and I think I made a point in your deposition, you yourself, an Ivy League educated guy, at first, you changed your position.
Yeah.
Okay?
I remember the thing about Ivy League, yes. And it is true, I did initially have that opinion. Yes, I changed it for two reasons. One, I did further research and found out case law that changed my mind. And second, I was concerned about the differences between the way it was represented and the way it was found in the field.
So when a statute is drafted where a reasonable person can't know the limitations of that statute, whether they're operating within or without, when somebody as educated as you are, law professor, Ivy League graduate, a guy who studies the law, when you flip-flop on it, don't you think that statute is vague to a reasonable person who's trying to operate under that statute?
No, I don't think so. I think under the law, people are charged with knowledge of what the case law is, interpreting it, and I just hadn't been aware of those cases, and I saw it later on. And then second, the statute itself uses the phrase slot machine, and I think that any fair observer would have to know that these machines seem to be awfully similar to slot machines and would put them on notice that they need to inquire about the legality of it. And in this particular instance, we put you on notice that they were not in conformity with the anti-gambling statute.
Well, let's talk about the statute. The statute says a reasonable person should be put on notice. It didn't say a reasonable person working with the DA's office the way we were working with you. That's different from a reasonable person. We're
I
talking
think,
about the vagueness
sorry.
of the statute.
I'm sorry, I didn't mean to interrupt you. Are you done?
No.
Okay. You go then.
Okay. All right. So the question is, a statute is written so that a reasonable person should be able to read it and understand the law. And we've established here, you read the statute when you met with me the first time. Is that correct?
Yes, that is true.
And you're even a notch or two or three above a reasonable person in this area in the fact that you're legally trained lawyer. Right?
It is true, I'm a legally trained lawyer, yes.
You're the district attorney.
Yes.
You look at these statutes all the time.
Yes.
And you had one opinion when you saw it, and then you did even further research as a lawyer, whatever, and you changed your opinion. Is that fair to say? That's a fair characterization of what was done.
It is fair characterization that I changed my opinion for the reasons I already outlined. If we're still talking about vagueness, then I need to say something else. But if all you're asking me is if I changed my opinion, yes, I did for the reasons I explained.
And let me ask you something. You talked about having some interaction with the Attorney General's office. Is that correct?
That's correct.
But you did agree that the Attorney General's office didn't order you to confiscate those games.
They did not, no.
They did not give you a directive that those games were illegal, did they?
So I need to be careful here. A directive, are you asking if they instructed me to, or if they asking if they gave me a legal opinion?
No, if they instructed you to.
Objection. I'm 25.
Mr. McMillan,
Your Honor,
the objection?
if they had any privilege on this, they waived it per the deposition. When I asked Mr. Mulroy this question now, you know, it's debatable how much the Attorney General's office was involved with that. But ultimately, you were not ordered by the AG's office to declare them illegal, were you? And he answered, I don't believe the Attorney General issued me any instructions. So he's already answered that question. If there is a privilege, he's waived it by responding to that question in a deposition with a lawyer with it. And there was no objection to that question whatsoever.
You answered the question whether there was a directive, but
That's the
whether he
question.
got advice from us.
Well, let's ask one question at a time. I think the question to Mr. Mulroy at this time is whether or not he received direction from the Attorney General. Is that now the question?
A directive from the attorney.
Yes, that's the question, and according to the deposition there, he previously answered that question. So, Mr. Mulroy, I believe it will require you to answer that question.
Yes, Your Honor. So to the question whether I received a directive in the sense of an instruction or an order, the answer is no. It is,
Question.
okay.
And,
It is the case that we consulted with the Attorney Generals throughout.
okay, and you said in the deposition that you were given the attorney general gave you an opinion, but I want to be very clear, because we're all lawyers, that when the attorney general does an AG opinion, that's a published thing on a particular issue, and there are only certain people can get that opinion from, people in the legislature, and people like you. The attorney general did not issue an attorney general opinion on this issue, did he?
That is correct. The Attorney General never issued a formal Attorney General opinion, what we lawyers in the business call an AG opinion. That did not occur.
At one point, let's go back to the point when we were on the same side. On one point, when you felt like it was your opinion the games were legal if they operated in the manner that, I think it's the manner that we've described to the court now. Your office was able to tell law enforcement to stop seizing the games, is that correct? And let me refresh you, I think Dennis Johnson instructed them to stop seizing the games, is that correct?
See, I'd like to see that email, because I know that I told Dennis Johnson to inform them that what my legal opinion was. But I don't really think I have the authority to tell them what to do. But I could tell them what the position of the office was in terms of what prosecution action we'll take. And we did do that.
Okay, in your deposition, and it gets a little nuanced here, in my questioning to you, okay, have an email here from Dennis Johnson to Lieutenant Fox, and that email is dated October 9, 2022. Mr. Rudolph, you've seen this. And it was during your deposition that I showed you this email, and this email really, it says in the last paragraph, D.A. Mulroy has given instructions on the disposition of seized gaming property and the funds. And it also, it says in the second paragraph, D.A. Mulroy has concluded that the machines within the new program no longer are gambling machines as defined by Tennessee statute. Please give me a call if you have any questions about the implications of this decision. And that was an email from Dennis Johnson to Mr. Lieutenant Fox, is that correct?
Yes,
And you know who Lieutenant Fox is, right?
yes.
Okay, and he was in charge of seizing these games, is that correct?
Yes, but I need to make clear that email tells them what to do with the machines that already have been seized, because our office handled, negotiating with Torch about, forfeiture and things like that, and it tells them what our position is. But the reason I was answered the way I did earlier is that I didn't understand that email to be instructing them about whether to continue seizing the machines or not, just what our position was.
Okay, and so we discussed this in your deposition, and I want to focus page 67 of this deposition, and there, part of the excerpts that we presented to the court. I start out, okay, but now I want to point to you, I'm going to make another exhibit, and that was this email. And before you speak, let the court reporter mark it. And then I say, a document was marked as Exhibit 4, and that's this document here. Same one we're talking about. And I said, and so we talked about in November when you initially made the determination the games were legal. Is Mr. Johnson accurate in what he's saying to Lieutenant Fox? And he said, as of November 9, 2022, yes. And I said, and so, all right, and so this is accurate. So you are letting law enforcement know, stop. And you responded, yes. You remember responding? So my question to you, it goes back to, you were able to tell law enforcement to stop the seizure of these games. Is that correct? That's what you said in that deposition?
Yeah, I don't dispute what I said in the deposition. My understanding is that I can tell them what our position as the office is going to be and what we're going to do, and that clearly is going to have some impact on what they do. Why would they continue to seize the machines if they know that we're not going to prosecute? But I just didn't think that I had the authority to direct what the law enforcement actually does. That's going to be for their commanders. But I did say to Dennis Johnson, let them know what our position is, because they needed to know we had changed our position, and you know, also what to do with the machines already seized.
And just so I'm clear, Mr. Johnson wasn't operating outside of his authority when he wrote that email?
No, he was not.
And he didn't say anything about you that was not true? He didn't misrepresent you at all in that email?
No, he did not.
Now, you talked about going back, looking at some case law, and I think you and I had a debate about that during your deposition. Explain to me what in the case law made you take a different position?
Well, the McTeer case, Supreme Court Tennessee case in 1914, and it basically said that, you know, even if you had a preview, it would still be a gaming machine because you were going to be looking for, you were hoping for disproportionate gain in the next round. And I've since learned there was another case, a 1941 case called Hartley, which said the same thing. Both those cases say, even if you can't lose, and even if you've got some information about upcoming rounds, it's still gambling under the Tennessee statute. And then we discussed in the deposition, I had also been shown 2 out-of-state cases that were much more recent that I thought were analogous. There was the male bingo case out of Ohio, and the, I believe, JB Games case, or JD Games case out of Wisconsin. And they also talked about the preview feature. And, you know, they said that nonetheless, it was gambling under their statutes. And so the cumulative effect of all of that made me think that this, especially since the statute is now broader than it was originally, that these machines would not comport with the anti-gambling statute.
Okay, you made a couple of things I want to address. First of all, the Wisconsin state statute is not identical to the Tennessee state statute that we're operating under now. Is that correct?
Not identical, but I don't think it's materially different.
Okay, and the Ohio state statute for gaming is not identical to the Tennessee state?
Again, not identical, but I don't think materially different. In fact, I think maybe arguably narrower.
And you will agree that the Tennessee gaming statute has been modified since 1914 with the Mulroy case. Do you agree?
It definitely has been modified since 1914, but what I think is significant here is that the Sentencing Commission comments say that the statute was designed to be broader than the prior law. So I think that means that McTeer is still a very useful precedent.
And who did you say, the Sentencing Commission?
Yes,
And so that is the sentencing commission is being used to interpret the statute, is that correct?
that is true.
And doesn't it on its face say the statute is not clear, it's vague when you have to take a sentencing commission to interpret it?
I don't think so. I think you take a look at those kinds of authorities all the time. I mean, I used to teach my students in criminal law that the Sentencing Commission comments were not as authoritative as the plain language of the statute, but they nonetheless were authoritative, and it was something that you could, in fact, look at to decide what the meaning of the statute was. And I think that's relevant whether we're talking about how to interpret the statute or whether we're talking about the notice and vagueness issue.
I understand. All right, let's talk about the 1941 case of Hartley, okay?
Yes.
In the 1941 case of Hartley, the Tennessee gaming statute had the word enticement in it, didn't it?
I'll take your word for it. I don't dispute that. Yeah, yeah.
Okay, it had the word enticement.
Yes.
It's something that would entice someone to gamble. And as of today, the statute doesn't have that word enticement in it at all, does it?
No, it doesn't.
The state statute today doesn't talk at all about the perspective of the player, does it?
It doesn't explicitly mention the perspective of the player, no.
And wouldn't it be fair to say that the statute really got narrow, not broader?
I don't think so. I don't think that would be fair to
Well,
say.
let me ask you this. If you add the word entice, you entice. It doesn't have to be gaming. You entice someone to play. They're talking about the player, aren't they?
I think they're talking about the player. I think they're just talking about the idea that the expectation of a disproportionate gain is what is the enticement, and that's inherent to gambling.
Right, and that's enticement to the player. Is that correct?
Sure.
And today, that word enticement is not in the statute. They don't have any of that in the statute today.
The word enticement is not in the statute, but the statute also was modified to say if it was in any way dependent on chance, which I think makes it broader than the statute that was in effect at the time of McTeer.
When you say any way dependent on chance, are you saying a player can turn any device into a gaming device by playing a game of chance with that? Is that what you're saying?
I'm not sure I know what your question means. Are you talking about the hypothetical we talked about in the deposition with a coin or a deck of cards?
Well, what I'm talking about is if they have the preview, the balanced viewer, and so it's not a game of chance. Let's just go to the configuration that we last offered in the August 10th letter, and what you thought it would work like when you said it would be legal. If you have the balanced viewer, and let's say it was 5 seconds, or like we did today, don't you agree that that is not a game of chance when you know whether you'll win before you actually play?
I don't agree. And first I have to say that the way you characterized it, if the two changes that you offered to make in the August 10th, 2023 letter weren't the totality of the things that had concerned me, because there was also the thing that we had talked about previously about being able to see the full balance of all future rounds. But to your question, I don't agree that it would be a game of chance for the simple reason that preview features were part of the analysis in the McTeer case and in the Hartley case in Tennessee. They were also part of the analysis in the male bingo case out of Ohio and the JD Games case out of Wisconsin. And nonetheless, they said the fact that there is some expectation of a disproportionate game in the next round, and the fact that you don't always have to use the preview feature, all of that accumulated to the conclusion that it was nonetheless a game of chance. That was my analysis.
And that's not the McTeer case, the Tennessee case, that was, it didn't quite interpret, but I think it did attempt to interpret the Tennessee statute. That was a different statute from today, is that correct?
Not identical, that is correct.
And when you put a balance viewer in there and you see all the outcomes, you're not, what next outcome are you playing for? If you put $10 in and you got 10 rows and you, as Mr. Miltenberger demonstrated, and you go through all 10 rows and you saw the demonstrative up there, and you add up whether you're gonna win or gonna lose, and then you can make it, what next role are you playing for? When you press the button and you get your $10 back, what next role are you playing for?
So in order to answer your question, I have to say that both the McTier case and the Hartley case said even if there is no chance of losing, the fact that you are expecting a disproportionate gain and are waiting on the results of the next round would nonetheless allow it to be considered to be a game of chance.
And they were interpreting the statute that talked about enticement. And that's enticing. It's enticing someone. But that was taken out of the statute. And it no longer exists in Tennessee. So there's no, and that's why, don't you agree? The statute is narrower now. It don't even include enticement. Even what you just quoted, it does not include that. It's a narrower statute.
Here's why I think it's not narrower, because the language was modified to say if chance was involved in any way. I think that makes it broader, and the Sentencing Commission comments also say that it was broader. So I think the statute is broader today than it was back in 1914 or 1941.
So you think a deck of cards is a gaming device?
So we talked about this in the deposition.
So you think a deck of, because I as the player can play this Tullis for money.
Mm-hmm.
Can I turn something into a gaming device based on how I play it?
So as I said to you at the
As
time,
a player, it's a question.
I understand. As I said to you at the time of the deposition, a deck of cards could be used to gamble, a penny could be used to gamble, but that's not the only thing they could be used for. And these machines can only be used to risk money for a hope of a disproportionate gain that is in some way dependent on chance.
Now, I think we established you're not risking any money because you can get your money back before you even play. So that's not a risk, is it? If I can put money in the stock market and wait until next week and decide whether I want to take advantage of that trade or not, that's a no-risk proposition. Is that fair to say?
Well, several things. First of all, the McTier and Hartley case said that even if you can't lose, it could still be gambling. But second of all, people do in fact lose money all the time on these using machines. That's how Mr. Miltenberger makes his money. And when, if I could finish, and as a practical matter, if you have to wait an hour in order to see your preview, you're not going to use that preview. So it ends up not being as fail-safe a proposition as you are characterizing.
I understand with the timer. We're not talking about the timer.
Okay.
Because we offer to get rid of the timer, modify the timer, and that's configurable.
Okay.
All right. So you keep going back to the Hartland and McTier case, but we've established that there was a different Tennessee statute that they were analyzing, which, in my opinion, was broader because they talked about enticement. They were talking about the player. The current statute mentions nothing about the impact on the player. And so you're saying if I choose not to look at the prize view, because I like the rush of that, I like not knowing, I like just playing the game. You say, is it a gaming device because I chose to play it that way?
Yeah, I believe that the fact that you can, in fact, opt not to use the prize viewer, and the fact that many people don't opt to use the prize viewer does exacerbate the situation. It makes it, I think, even more clearly a gaming device, as the Wisconsin court in the JD Games case said. They analogized it to a video poker thing where you have the option to play for money or not play for money, and the fact that you could play for money made it a gaming machine.
You're talking about Wisconsin or Ohio case?
I thought that it was the Wisconsin case, yeah.
It doesn't matter. It's not a Tennessee case.
You're right, it's not. These are analogous.
And it's not the exact same statute.
It's not, nope.
Okay, let me go back to this so that I understand this. So, if a player chooses to play it without knowing the outcome, you say that's on Mr. Mulroy. When he produced the machine that they can find
I'm not talking,
Are you saying that's gambling? If I choose not to know the outcome, okay? I like betting on stuff. It doesn't matter what the static outcome, I don't know it, so I like betting on it. If that's my choice, you're telling me I can convert something into a legal gaming device based on how I like to play.
I'm not saying that you convert anything, and I'm not saying about what is on Mr. Miltenberger or is not on Mr. Miltenberger. What I am saying is the fact that you have the option to play it without the preview feature, and that so many people do, I think just makes the situation worse. It makes it more clearly a gaming device.
A lot of people play poker. I want to know if you want Milton Bradley to get rid of the ace of cards, because a lot of people play poker and they play it for money. A lot of people, okay? Does that make a deck of cards a gaming device?
Not inherently, no.
Okay, and Mr. Miltenberger's machine. There are a lot of people who come and go through the outcomes and choose not to play and take their money. Okay, and there are some that go through the outcomes and see that they're going to have positive outcomes, and they play the games. You realize that, right?
Yes.
Okay, those people are not gambling, right?
I'm sorry. I need you to repeat the question. I'm not quite sure where we are now.
Those people who look at the outcomes before they play and make the decision to play or not play after they've seen all the outcomes, those people are not gambling, are they?
I would say that they are still using a gaming device under the case law.
I understand you say that, but are those people gambling, yes or no?
I honestly don't know. I think you could still make an argument that they are gambling because of all that case law that talks about that it's still gambling even if there is no way to lose because you're looking for an expectation of disproportionate gain depending on the outcome of the next round. So I'm not really sure.
You're not really sure whether they're gaming or not. Okay. And then a person who comes in, like a player who likes the rush of not knowing, a player who will know a game was played the night before, but they don't know the outcome, they'll bet somebody. Someone like that who doesn't want to know the next outcome because they like the rush of that. Is that person gambling?
See, part of the reason why I still think we're talking about gambling is that I believe there's case law that says even if the prize viewer feature is mandatory, it's still a gaming device.
Case law, what state is that now?
I'm trying to remember now. I don't remember offhand.
But it's not in the state of Tennessee.
No, it's not a Tennessee case. No.
So theoretically, there may be some case law out there that say that, but we're looking at this. And so you say, in my understanding, from my inquiry here, you said a person can make an argument about the first two examples, the people who watch it all the way to the end. So they can make an argument. So that's kind of up in there. That's vague to you whether they're gambling. Wait. Let me finish.
Sure.
You made the statement, and you said, I can make an argument for that, but you really equivocated. So that's kind of vague. And then I asked you about the third person, the one who does not look, know that they can look, but choose not to. And they just play the game. Is that third person gambling?
I think the person that doesn't look at the prize viewer, I think it's more clear that they are gambling, but I think what I need to say here is, in all those hypotheticals that you just mentioned, the device itself, I think, is still fairly characterized as a gaming device for all the reasons I discussed and all the case law I talked about.
That torch machine had been characterized, no court has characterized it as a gaming device. Who are you saying has characterized the torch machine as a gaming device other than you?
I mean, the machine itself is a gambling machine.
Says who?
I believe it's clear from the case law.
From Ohio or Wisconsin,
No, but from McTier and Hartley as well.
prior to the statute that we're analyzing another now?
Yeah, which a statute which I think has become broader.
Give me a second.
based on what I know about the possible configurations, no matter how you change those configurations, it's still a gaming device.
Okay, if you configured the game so that you didn't put any money in it,
Oh.
and you would go through a number of clicks until you know the outcome of those clicks, and you have the opportunity to put money in or not, based on your testimony, it's still a gaming device.
So are you talking about a situation in which the player at no time ever puts money in?
Yes.
So I guess, and so it's not a question of they look at the viewer without putting money in, but then in order to claim their prize, they have to put money in. You're not talking about that situation.
Yes.
You are talking-
If they choose to get the money, if they choose to get their prize, they can put their money in. But they already know they haven't put any money in. Is that a gaming device?
Yes.
Okay? If they clicked it through and was able to see what they'll win without putting any money, and just press it and get a prize, would that be a gaming device?
So you're talking about a situation in which at no time, either before or after looking at the previews, before or after receiving their prize, the player never inserts money in.
Never inserts money.
Then I think that probably might very well take it outside the ambit of the statute because you're not risking anything of value. The person never puts money in at all.
And that
The
machine.
person walks up with no money in their pocket and plays the machine.
Right. And that machine can be configured to do that, but it's still a gaming device.
Okay, so,
No, that's what you said. You said you think the machine in and of itself is a gaming device, and I gave you hypotheticals of its use.
Right.
And you said the last one is not gaming, and we talked about it being configurable, right? And we talked about it has software that it can be configured in multiple ways. Is your opinion that machine, just by the way it looks, is gaming?
so my answer back then, like a minute and a half ago, was based on what I know about the way that it can be configured. And now that you've told me something else, you've told me that there's a new configuration that I was not aware of. Under this configuration, a person with no money in their pocket can walk up and at no time ever put money in, not even either before the preview, after the preview, before they get their prize, after they get their prize. At no point is there ever going to be an exchange of money between the player and the machine. That is a new configuration to me.
Yeah,
Right? So,
well, I started out telling you it's a software package. You remember when we started, we talked about 1914 and 1912, you didn't have that. And I said to you, the machine can be configured anyway, and I gave you 2 or 3 configuration styles that it can be done. And you sat through the trial, you saw that it can be configured anyway, you saw that, and I gave you one, and you were saying to me that that last configuration, and you said you didn't think about that when you made your earlier statement, but that last configuration is not gaming, and so therefore, it would not be a gaming device at that point.
So the new configuration that I was not aware of, in which there's never at any point, before, during, or after, does any person ever put money in, then I think that there's an argument that that falls outside the ambit of the statute because they're not risking something of value.
Today's statute.
Today's statute.
What about the 1914 statute that talk about enticement? Even though you don't put any money in, the whole bells and whistles, does that entice you to gamble?
I think that the earlier statute, which I don't remember the exact wording of, nonetheless talked about gaming, and it didn't define it, right? But there was an understanding at the time of what gaming was, and it was what we normally think of as gambling today, because gambling was a well-understood phenomenon in 1914, as it is today. So I don't think the statute back at the time of the McTeer case was, in fact, broader. I think the statute today is broader.
But you do agree that that statute has enticement in it?
Based on your representation, which I earlier took your word for, I have no reason to dispute it, the word enticement, because we talked about the Hartley case at the time, and you said, just take my word for it, that enticement was in the statute that was in effect at the time of Hartley. I have no reason to dispute if you tell me that it was in effect at the time of McTeer as well. What page?
The very first.
Okay, I see it.
So we can clear that up. So there's no misrepresentation about it. And so my question.
At the time of Hartley, the word enticement appeared.
Yes, yes. And you have you cited no other Tennessee case since enticement was taken out that's applicable here, other than in other states.
Right. No, that is true. Mhm.
It's Mulroy. It's always intimidating, examining a law professor, but that's all I have.
Redirect.
We have no further questions, Your Honor.
Ms. Stevens, you have any questions?
I do not.
Mr. Henry?
May I step down? Thank you, Your Honor.
Next witness?
Your Honor, the defendant rests.
All right. You have anything further?
We don't have anything.
All right. Court will take a recess and deliberate, and then we will come back out and advise you of what steps we'll take next. All right?
All right.
Here's what we want to do going forward, is to allow each of you 15 minutes to give your closing summation, and we're going to do that directly. Thereafter, we will take the case under advisement, and then we'll issue a written opinion on the matter. Is 15 minutes sufficient for you?
Yes, Your Honor.
Or is it too much? I mean, I don't want to choke you with it. Yeah. If you can do it in 5, we'll take 5. But I will allow you 15 minutes. All right, the plaintiff can go first. And while Ms. McMillan is preparing, for the record, we have received Exhibit 12 and its redacted form. No objection. It is admitted as Exhibit 12.
Your Honor, we filed this declaratory judgment for 2 main reasons. First, to clarify that the operation of Torch, the Torch amusement device does not violate the Tennessee gaming statute. Second reason is alternatively, if it's deemed to violate it, the statute is vague, constitutionally vague under the 14th Amendment and under the Tennessee Constitution. It does not give our client notice as to what is legal and what is not legal with respect to gaming. Our client has a complex amusement game that we know is configurable, and I think we saw from D.A. Mulroy, who is an accomplished lawyer, that you could have multiple interpretations and it's kind of up in the air. D.A. Mulroy initially said that the game was, if it was configured a certain way, it would be acceptable under the gaming statute. He later on came back, and even today, and initially said almost any configuration of the game would not be acceptable under the gaming statute. And through a hypothetical drill, I think he settled on one configuration may not be a gaming statute, be a violation under the gaming statute. We say that it's constitutionally vague with respect to Mr. Milton Berger's game. And I think it's interesting, and one issue we have here in this state, we don't have legalized gambling. So it's not a well-developed law as far as what's legal and what's not. Like in other states that have legalized gambling, there's a lot of opinions about that. So we have 2 main opinions from Tennessee, and one is the Hartley case in 1940s case, and one before that, a 1914 case. And all of those were interpreting the Tennessee anti-gaming statute, gambling statute at that time. And that statute talked about enticement, and it's in my opinion, it was broader, and it talked about the impact on the player. And as you know, over time, the public sentiment about gaming has changed. This state has a lottery. There were changes made to the law to make that acceptable. The state also has online gaming. And so today we have a more refined statute that is a little narrower, is narrower than the statute back in the early 1900s. And in that statute, there's no contemplation on how a person plays the game. It identifies exactly what gaming is, and the key point is if they're a game of chance. Now, it does not limit it to if a player plays it, so it seems that there's a game of chance. That would be a person not looking through the outcomes through the balance viewer. That would be a person making that particular apparatus a gaming device by the way he makes it. I don't think the statute really contemplate that being something that makes it a gaming device. A gaming device is, and we had testimony from experts that a slot machine is a type of machine. It has a randomizer in it. It has numbers randomizers, not a static script. You can't see what you're going to win, and you can't come back and see what you're going to win later. A slot machine is a totally different thing. Now, it's not lost on the court that Mr. Miltonberger's machine is designed to look like that. I mean, we saw it. It looks like a slot machine. But so does those games you play on your iPad or on your phone when you're on the plane. They have a little, there's no money going, but you gain so many tokens or whatever. Just little games. People like to play amusement games, okay? And they may look like, and there's no question it looks like a slot machine, but it does not operate like a slot machine. And it can't be really configured to operate like a true slot machine. So what you have is an amusement game. People play games for different reasons. They spend funds on things for different reasons. We have here a game, okay, that is clearly, does not reach the level in the Tennessee gaming statute because it takes chance out of it. If a player does not want to chance anything, the player has the right to look at all the outcomes of the money that they put in, okay, bet on a certain denomination. So we use 10 in the example. A person can see whether they're going to win, have more positive outcomes or more negative outcomes. And that person then has the opportunity to cash in and take the money that they had put in the machine, or they can play the games and take the money that is a result of the outcomes of the game. That is not a game of chance. Now, we talked about, and so when it's not a game of chance, it seems like the issue we have here, and we'll concede 3,000 seconds was never that was a default setting. It was never set up to be, this is the way this game is going to operate. You saw through the correspondences back and forth, Mr. Miltonberger's team reached out to DA Mulroy trying to determine what number is acceptable to you. What number do you think? Is it 5 seconds, 10 seconds, 15 seconds? Because as Mr. Miltonberger explained on the stand, it does not matter if someone can see the outcome. His business model is he's going to make 9% if they go through the entire static script. And you say, why would it go through the entire static script? Because there are different points where outcomes are better and worse. And it just depends on when the player comes in. The player can come in and play 5, not 10, and that player leaves with a return. The next player can come and play 15, not 10, and where if they stopped at 10, they would have had a negative outcome, but they kept it 15, and they had a positive outcome. Only that, the fact that the players can see the outcome does not interfere with Mr. Miltonberger's business. So it's no backroom secret thing that he's trying to deceive or trick the user one way or the other. His business will make 9% if it goes through the entire static script, and it's 60,000 outcomes, and so that will go over It's not one individual. So his business model is not built on deceiving the player. This is not a slot machine like in Vegas. His business model is set on the static script and how it operates. And so from that standpoint, setting the timer took up a lot of the case, but the timer is kind of really irrelevant. If it's a legal gambling machine on 3,000 seconds, then what is it on 15 seconds? What is it on 10 seconds? Whatever. Yes, anything can be constructed so that you can operate a game of chance. And I think that was the example we tried to make when we were talking about a deck of cards. You can play a deck of cards in a manner, poker, and with money in a manner in which you're gambling. Or you can play with a deck of cards with no type of winnings or losing or no money involved, and it's not gambling. But that does not make a deck of cards a gaming device based on how the player plays it. And that is our position with the torch game. A person can play that game in a way that he's getting the feel that it's a game of chance. That's the person who does not look at the balance view. He gets that feeling that it's a game of chance, and he just likes playing that way. The same way on your phone, you can play these little slot machine games or whatever it's supposed to. There's no money exchange. There are little tokens or whatever. You see if you win or lose and move on. That's why the torch game is an amusement game. Now, it can also be played where there's no chance and there's nothing to prohibit anybody from doing. There's no hiding the prize viewers. None of those things. All those things imply that Mr. Mittenberg is trying to be deceitful to players or whatever. I'm sure in some form or fashion, someone could change the configuration after they've agreed to it. And I'm sure that could happen, but we're talking about the machine. And if the machine lets the player know what the outcomes will be before they risk any money, I say to the court that it is not gaming. Something else I wanted to point out in D.A. Mulroy's statement, he made some comment, and it was the first time I heard it, and I asked him about it. He was talking about how could he regulate what the timer would be. And you saw with the game that we had here, when you walk up to it, before you put any money in it, the first two rows, there's no timer, but you will see at the bottom, it'll say what the timer is. I think we looked at one exhibit where it dropped down to 2,900 and whatever after the roll. So there's no real complicated process to monitor whether the timers are where they're supposed to be. You just tap the thing and it'll show you the time for the next, and so it'll start at 3,000. So, and that's kind of administrative, but that doesn't go to the heart of what we're talking about. And what we're talking about is whether this is a gaming machine. And let's talk about Mr. Miltenberger for a second. Mr. Miltenberger reached out to the previous district attorney, but it was before the election or whatever. The previous district attorney, D.A. Wyrick, lost the election to Mr. Mulroy. Mr. Miltenberger's team continued to reach out to them because one thing he knew is this is complex. It looks like a slot machine. It's easy. And when police officers are in the field, they're not lawyers, so they're not going to do a legal analysis of it. They're given, just a basic money in, money out gambling. Okay, Mr. Miltenberger knew that's the default for police officers. And no disrespect to police officers, they run into all type of situations that probably require some level of legal analysis. But when you're training police officers, you got to give them the quick shot on what they're looking at. So Mr. Miltenberger Millenberger knew that money in, money out is the edict, and that would prevail. And so he went through great pains to meet with the DA and explain the police department, everybody, to explain this is how my machine works, and this is why it does not violate the gaming statute. And Mr. Mulroy admitted that initially he thought with certain modifications the games would be okay at some point. He changed his mind. He denied changing his mind based on frustration. He said he changed it after looking at the statutes again, but I submit to you, Mr. Mulroy looked at the statute when he made the first decision anyway. He didn't just make it off the top of his head. He hadn't been that type of person in our dealing with it. But can reasonable minds disagree? I think that question is answered. Is the gaming statute vague to a reasonable person with respect to, especially this game? Is it vague? I mean, I think it says it in and of itself because we are here. And then the other thing is analyzing the game and the configuration that we saw today, we saw over the last 2 days under the gaming statute. We think when you do that analysis, you will realize that the game does not violate the Tennessee gaming statute. The game is unique in that it looks like I hate to use the word slot machine, but it does not operate like a slot machine and cannot be configured to operate like a slot machine. Keep in mind, there's no random number generator. It's a static script. The owner can't come unplug it and plug it, and it resets so that he can change the overall progress of the static script. It starts back where it is, and it's unique. And it took a lot of, there was a lot of thinking, a lot of research, a lot of software design going in to create this game. And I don't want to get sidetracked about the way the game looks or whatever. And Ms. Millenberger will admittedly tell you it's designed to give people who like playing those games the feel of playing those games. But one thing it does not do, it does not violate the Tennessee gaming statute. And quite frankly, it was designed so that it did not do that. And I don't think when you look through interpretation, I mean, we're all lawyers, but you all are the ultimate decision makers on that. But when you look at statutory construction and you look at the facts, it is our opinion that this game does not violate the gaming statute, and to the extent that there's ambiguity, the statute is vague and unconstitutional under the 14th Amendment. Thank you.
Thanks, sir. Mr. Rudolph?
Please, I have some notebooks for the court to help me kind of
All
get through
right.
this closing argument. Got 3 of them, one for each of you. Please, the court.
Yes, sir.
This case is pretty straightforward. They said they're designed to look like slot machines. Well, they are slot machines. They have a prize viewer, and under the law, they're still slot machines. They're still gambling machines. In the tab number 1, and I put the statute, the gambling statute in there, and it defines gambling as contrary to the policy of this state and means risking anything of value for a profit whose return is to any degree contingent on chance. Very broad statements. and then specifically mentions slot machines. Now, not all slot machines are necessarily gambling devices, but the clear purpose of these machines is to bet money and in the hopes you're going to get more. This isn't this isn't Pac-Man or any other machines where you're just, this is to win money. And a gambling device is anything that's intended for use in gambling or used for gambling. So if there's any aspect of these machines that's used for gambling, then they're illegal under the statute. If you go to tab 2, if you look in the statute in Tennessee Code Annotated, there are the comment sections. This is what it says. The definitions are intentionally broader than they were in the prior law. It mentions it's broad and it's meant to get any unnamed scheme whose value is risk for profit. I mean, very intuitive comments by the Tennessee Sentencing Commission. The court has to take into account in interpreting whether we have a gambling machine in this case. The cases, in Tennessee law, we have 2 Tennessee Supreme Court cases that have considered this. A slot machine with a prize viewer. 1914 case, the McTeer case. It's clear that that one had a prize viewer, didn't have as many outcomes as this case, but it was illegal under the law. Followed up in 1941, if you go to the next one, tab 4, the Hartley case. And the court emphasized the great weight of authority from other states, as well as Tennessee, that if a person gambles, that a slot machine with a prize viewer is illegal, and emphasized the language, the player gambles not on the immediate return for the coin he deposits, but on the hope or chance that the indicator will show a profit on his next play. These are 2 Tennessee Supreme Court cases. Now, they've talked about the statute. I can provide a copy of I had to go back and look what was the original statute. I've got copies for the court if you want to look at it. Shannon's Code, that was how they did it before. If you want me to, I'll be glad to provide it to the court, where you can see what the gaming statutes were back when these cases came out. I don't think the Hartley case puts all the statutes. May I provide that to the court?
You might want to provide that to us.
I'm not going to spend a lot of time on this. This is the code that was in effect. This is 1917. I'm sorry, I had to go back and try to find what did the statutes look back then. But there's a whole bunch of statutes that deal with the gambling. If you look at the statute on the second page, talks about gaming, which is gambling. And then the annotations on the third page talks about gaming is defined. And it's defined, and this is back in 1901, the Tennessee Supreme Court said gambling is any agreement between 2 or more persons to risk money or property on a contest or chance of any kind. Very similar to what the statute is now. It's any kind of chance. So the Tennessee Supreme Court cases that we cited said under the law, as it was in effect, that is gambling when you have a slot machine with a prize viewer. So the Tennessee case is very persuasive authority in this case, if not precedential. They are Tennessee Supreme Court cases. To go to the facts of this case, we go to tab 5, the Baker-Donaldson memorandum, and this is what they said you could see the entire balance of the script. Well, we learned in this case the script is 60,000 outcomes, and that's just for one amount that you're betting. But they made a number of representations. You can see the entire script. Well, that's really not the case. We got it, the district attorney's office investigated, and you heard from our investigator, went out there and looked at these machines. What were they like? How are they in Shelby County? Well, if you look at tab 6, these machines are in convenience stores throughout Shelby County. They're lined up in a row, just like slot machines at a casino, but they're lined up and they're at a convenience store. If you go to tab 7, this is a picture of one of their games, Classic Cash. Now, if I had to design something, if you asked me to draw a picture of a slot machine, this would be it. I mean, what's the purpose of this? Classic Cash, they got dollar signs all over it, and they indicate that if you bet 50 cents, you could get $250. I mean, this isn't a fun or amusement game. This is a betting game. They're betting on these machines, and it's just, this is, you know, they can dress it up with software and make it look, you know, modern and all, but this is a slot machine. You got the 3 columns and they spin it. And it's pretty clear. So we went out and tested these. If you go to the next, number 8, you remember the photograph where we tested it? It said 2,993 seconds. And they said, oh, you can see the entire outcome. Well, you can't. Our investigator goes out there and he presses it twice, and it's a 3,000 second timer. Now, Mr. Miltenberger testified that he set the timer and had advice from counsel on that. That's what he testified to. And they say this is a default timer, but who does it benefit to have a 50-minute timer on these machines? Because if you have a 50-minute timer, people are going to bet. They're not going to use this prize viewer. They don't make any money. If you use the prize viewer just to look at it and think about betting, they want you to play. They don't make any money unless you play. And if it's 50 minutes, who's going to sit there for 50 minutes and wait for the next time where you can hit the next button? And not only is it 50 minutes, their expert, Mr. Farley, said it's once you hit it twice and it's 50 minutes, then it's 50 minutes each time you hit the next button. It's going to take you a long time to get through, to ever get to see whatever balance you might have. But that's something to think about as well. If you look at the next tab, number 9, the signage that was on these machines. I mean, they say tickets over $500 may be paid out by home office. Again, it's not about amusement. This is about betting money and putting $500 in your pocket, or if it's even over $500. You got to be 21 years to play. They say that's a business decision. Well, people are betting money that they don't want children playing these machines because they're betting money. Indicates it's a gambling machine. And tickets will be printed to the nearest dollar. If you got, you know, they keep it, you know, if you got less than $1 in there, they round it down. So they keep that money. So we investigated these machines. We saw them in operation. If you go to 10, we've talked at length about the cease and desist letter. I mean, this doesn't happen very often, but, you know, District Attorney Mulroy met with these people. He talked to them. We analyzed it, had people go out and investigate it, and took the time to say, this is why I think these are gambling machines. I'm changing my mind because I've looked at the law. I've looked at your machines. You're not shooting straight with us. They can't look at the entire balance of the previewer. And he said, cease and desist. Pretty similar to a court saying cease and desist. It's very, very significant language. This is from the District Attorney of Shelby County, who's the chief law enforcement officer in this county, telling the Torch, Mr. Miltonberger, you guys need to get your machines out of Shelby County. And what did they do? If you go to look at 11, cease and desist as of August 10th, 2023. This lawsuit was filed July 30th, 2024. And there's been an amended verified complaint. But all the time since this cease and desist, they're putting machines in Shelby County, 2023, 2024, 2025. And they're reaping the revenues all along the way. If you're told to cease and desist and then you ignore it, you are intentionally violating the law. You are intentionally violating the gambling statutes. You are intentionally promoting gambling in the state of Tennessee. It doesn't matter if your attorneys say it's okay. We looked at their positions. We looked at these machines. District Attorney Mulroy made a determination, and they didn't abide by it. If you go to tab 12, Torch markets their games as no chance games. That's what they call, that's their marketing term, no chance. But we've seen the evidence in this case. They need to call them nothing but chance games. We saw 60,000 game outcomes in these cases. If you look at tab 12, 60,000 game, and that's for 4 pools. So you have 4 different betting amounts. And there are 5 game themes on there. So for that machine that we had in the courtroom, there was 1,200,000 total outcomes by my calculation. So when they talk about chance, nobody's going to be able to memorize this script. You're going to need, there's no way to determine this script. If you play this machine, you're not going to know what it's going to do. You can't memorize it. You have no idea where you as a player are in these 1,200,000 outcomes. If you look at number 13, we had testimony about the payout percentage. They said they go on the low end, so it's 91%, so that they no matter how they've set up the game, they've set up the script so they win. If the player doesn't know there's 60,000 outcomes. If you play the 60,000 outcomes, you're going to lose 9% of your money. But that's the stuff of casinos. The house wins. Slot machines and casinos, the payout percentage. It's designed so you're going to lose. That's an indication that these are gambling machines. We saw the chart they put up. If you look at number 14, they put up the chart about the $10. Took them a few minutes to kind of get through it. Didn't take them too long. But if you have a 50-minute timer, first 2 outcomes, you hit it, it's going to be 50 minutes after that. And then the next 8 outcomes, it's going to be another 50 minutes every single time. And if you do that, that demonstration would have, if they brought the machine that they're putting in Shelby County, that would have taken 7.5 hours. We wouldn't have been able to get much of the trial done yesterday. We would be waiting for the timer. Then if you look at tab 15, they have 60,000 outcomes. If you're fortunate enough, you put in $60,000 in this machine and you want to see all the outcomes, to be able to see it, put the first 2, that'd be 50 minutes, and then 59,998 outcomes. You push all the buttons, it would take you 5.71 years to look at all the outcomes. Now, so when they say, well, you can see the entire script, it's absurd. And to think that 50 minutes as a default timer is the right outcome, it's amazing. But what about people that don't use the timer? Number 6, look at number 16. This was in the first hearing before the court. He admitted there are people that play this game without hitting the button, the preview button. They are, what they do, they're gambling when they do that. And under the law, that's that's not allowed. We've cited the other cases from Ohio, other cases, the JP Prime case from Wisconsin. Those cases are right on point. They're dealing with these types of machines, modern opinion, and they, you know, they don't have an answer for that. All they just say they're in another state, but they're persuasive authority. And couple more points. They said in their complaint they've lost $100,000 in revenue. Somebody is playing and losing on these machines. They're not winning. They're gambling, and they're reaping the benefit of it. And the final point, we had testimony about that consent order in criminal court, and that's in tab 19. There was a consent order that was, they seized it after we told them to cease and desist, or MPD. They go to the court, and the court says, their torch is represented by counsel. They entered the order December 18th, 2024. That's after this lawsuit was filed. And when you go back and look at the consent order, they have admitted that the 6 torch devices were gambling machines. I would say they've admitted that nothing vague or unconstitutional. They entered a consent order signed by their own attorney that their gambling proceeds, that money should be forfeited that had been seized under the gambling laws.
And then the next is a email from Bruce McMullen to Dennis Johnson, November 30th, 2022.
Well, we'll admit that one as Exhibit 19. Do you have copies of those for the court? You probably should get those to us so that we'll have a complete record, because the exhibits will remain with the court reporter for the time being. And if you all need the exhibits, then you'll need to see the court reporter. Yes, ma'am, Ms. Tools. You were about to say something?
Oh, would you like for us to make copies? Would you like for us to make copies now? Of Exhibit 18 and 19?
That would be fine if you could get them to Ms. Duckett. She will distribute them. I must say that you all have done an extraordinary job, and it is an important case, which we 3 agree. I think I can speak on behalf of these 2 judges. You have not disappointed in your presentations. We expected that you would research the matter well, and you have done so. You have argued well and have presented efficiently and effectively and not wasted the court's time, and we are appreciative of that. I don't know what the outcome will be, but we will talk about it, and we will give you our best effort in coming to a decision for you. With that said, be safe, and we stand adjourned.
All right. Unfortunately, adjourned, may be dismissed.
Return the stuff to the state, since we'll fit in my suitcase.